Hey everybody, it's a rainy Monday here in Atlanta, and I'm obviously dressed for brief writing and not court. But I did want to talk to you real quick about what everyone is talking about, the unaliving of the United Executive in New York. Because I got some questions over the weekend about what I would do, how would you possibly defend this case? And so I wanted to give you a really fast breakdown of how a criminal defense lawyer looks at an unaliving case like this when they first come across your desk. So obviously, make it clear to you, I would never have this case. I'm not licensed to practice in New York, so I'm just giving you my general ideas based on being a lawyer here in Georgia that has handled these cases before. So really, when it comes to unaliving cases, most of the defenses break down into one of four flavors. The first flavor of defense is, it wasn't him, you got the wrong person. The second flavor of defense is, the victim needed it, deserved it, which is some version of self-defense, okay? The third flavor is, I didn't know what I was doing. I had some version of a mental defect, mental health issue. And the fourth is, it was an accident, all right? Yes, there are other defenses beyond those four, but most cases break down into one of those four categories, okay? So now, I will say this too. I have had a case, an unaliving case, where we used the defense that the person actually wasn't unalived, that they took too many unprescribed pills. And so that was kind of a weird side note. I did have a case like that. But again, back to those four major flavors. So in the case, based on what we know right now of this case, we can kind of analyze which ones we won't use. The first thing that I would look at is numbers 2, 3, and 4. We have to be sure that number 1 won't work for us. Number 1 is the only one of those defenses where you don't admit that you did it, because numbers 2, 3, and 4 require you to say, yes, my client pulled the trigger here, but, and then followed by whatever that defense is. So once you go out on that limb, especially in front of a jury, you can't go back. You can't say, oh, did I say I did it? I mean, it wasn't me. So that's part of the analysis is, are you even willing to go out on that limb to begin with? And if number 1 is not going to work for you at all, and you can't get, like, say, a confession suppressed or something like that, or you can't make them realize that the DNA evidence or something like that is wrong, then, then you're looking at 2, 3, and 4. But there's other ways we can knock some of these off the list. Based on the video, we know that it didn't look like self-defense. The only way, and I was kind of throwing this around in my mind for a little bit, the only way I could see, based on my understanding of the facts, that you could get a self-defense out of that might be in a case where maybe they had a personal relationship, maybe there was, sometimes we have cases where there's ongoing abuse that kind of drives someone to do that to protect themselves. There's nothing to indicate that's the case here, but that was really the only thing I could come up with where you might be able to use a self-defense argument. And then there's the, it was an accident. I don't think that would fly in any way that I can see based on what we know about this case. Him lying in wait, being so calculated, that's just not an accident. So that leaves us with the 2 flavors. Number 1, it wasn't me, and number, I don't remember if it was 2 or 3, which is I had some type of mental defect or mental incapacity. So I will tell you that with regard to NGRI, is what we call that in Georgia, not guilty by reason of insanity, getting a verdict like that is actually incredibly rare. I think people think because of the things they see on TV that it happens all the time, but it doesn't. It's a very big hurdle. So you have to, in Georgia, you have to basically prove that the defendant didn't know right from wrong. I had to look up the New York statute because it's a little bit different, but the New York statute sounds like it breaks down to you didn't understand the nature and consequences of what you were doing, or that you didn't understand that that conduct was wrong. So the hurdle that we see based on the evidence we have right now is this was calculated, thought out, and the escape process was done, at least for now, very, very well. So that's going to cut into the I didn't know right from wrong kind of thing. But where you might be able to make it work is if there's just so much, they end up with so much evidence that you can't deny that it was this person that did it. You may be able to argue some type of mental defect based on some level of grief or pain that when we've seen that this looks like there's some commentary of the insurance industry here, right? That maybe that caused this person so much grief or pain that they weren't thinking clearly. I'm not sure that you could get to the bar of just didn't know right from wrong, but you might be able to mitigate it. You might be able to be found guilty of something lesser, or at least you might be able to get a lesser sentence. That's just a possibility. And then, of course, we have number one, which is it wasn't me, where you attack the DNA, you attack any kind of identification. There's always the possibility of an alibi defense that says I wasn't even there. So that's the basic analysis. And I will tell you, too, sometimes we don't pick our flavor early on. We have to wait and see what the state provides us in the discovery before we know which way we want to go. But in the end, if you pick 2, 3, and 4 and you go out on that limb and say, yeah, it was me, but you can't come back. So that's my basic analysis. I hope that's helpful to you. I hope that answers, some of the questions. I don't practice in New York, so I can only give you a general idea. But if you have big questions or comments that you want to make in this case, let me know.